Now, back to Access Tech Live, the latest in tech and accessibility with Stephen Scott and Marc Aflalo.
Welcome back to Access Tech Live. Now joining us now is a familiar face to viewers of AMI and listeners to AMI Audio as well. He joins now with Dave Brown regularly, as well as the team over at Kelly and Ramia as well. David Lepofky is the chair of the Accessibility for Ontarians with Disabilities Act Alliance, and he's also the visiting research professor of disability rights at the Faculty of Law for the University of Western Ontario. David, I hope I got all that right. Good to have you here with us on Access Tech Live.
It's great to virtually meet you.
It is great to virtually meet you too. I'm just going to guess you're a tech head like us, aren't you? A huge fan of technology?
I can't avoid buying it as soon as I hear about it, which is why listening to you guys is a very dangerous thing for my bank account.
Absolutely. Now, look, I want to talk to you about AI, of course, because AI is in the news all the time. And we heard earlier about that story of OpenAI in the New York Times. Where do businesses stand with this? And how does AI itself stand? Companies like OpenAI, for example, legally when it comes to the way that they essentially train their language models. How does that stand legally as far as you know?
Well, as a fan of Star Trek, we know the opening word, space, the final frontier. Well, when it comes to law, I would say AI is the final frontier. We are boldly going where no law has gone before. The thing is that when we deal with law problems, we lawyers think in terms of precedent, which in other words means we try to think about how we solved the problem before, which is almost the stupidest way to try to solve a problem that's never existed before. So trying to take 19th or 20th century legal concepts and graft them onto a purely 21st century thing is a real challenge. You take copyright principles or patent principles that were evolved, I think at the time of the printing press, and apply it to AI, and we're running into difficulties. So when I look at just delve into this, and it's not a specialty of mine. I'm 66. I retired from practice as a criminal and constitutional law. If I was starting today in law school, I'd want to specialize in AI in the law because it's a whole new area. So when you hear about these lawsuits, Stephen, like whether a company, an AI company is making improper use without compensation of the New York Times or other news things, they got an argument at one level. You usually pay for the paper. And here on a mass level, a company is essentially getting the benefit of buying the paper without paying for it, much less paying for all of the earlier editions that they're getting the benefits from. So at one level, you can understand why the New York Times is concerned.
But David, wouldn't the New York Times want their information to be, doesn't it validate what they're doing? I mean, they put out the information for people to consume. And normally when it comes to copyright, it's about using it and gaining financially, right? Right now, there's no real set model in any way, shape, or form on how these companies are even making money on it. So does it kind of compare with copyright law, or is it just, are we just in a whole new league?
Here's where the problem is. When we have a legal challenge like this, there are two ways of trying to figure out how to solve it. One of which is to look back at old legal principles and see at common law if we can graft them onto a new problem and find a solution. We have freedom of expression principles that were created at a time when the way you communicated was by maybe printing a pamphlet and handing it out in the town square. And now you try to apply that to Facebook or Twitter or whatever. The other way of doing it is saying, look, we don't even pretend that those old principles are capable of being transformed, or it could be pretty arbitrary. So why don't we come up with new legislation? And I would see that there's going to be a lot of pressure on governments to try to figure out, and legislatures and parliaments to figure out, can we come up with a new way to balance all of this? Newspapers came up with the idea of charging you for a copy of a paper or an online subscription when it's one human being consuming either one paper or subscribing to read online. and maybe letting you share the password with a couple of people. When AI does this, it's the equivalent of thousands and thousands of people doing it, and maybe with only one subscription or none. And newspapers can't make
But
money
there's a
that way.
difference here, though, David, isn't there? There's a difference here because the difference being is that people can then take that information and they can regurgitate it and represent it to someone as their own work. And that is ultimately the problem here. It's not necessarily that their information is being used I know that the argument in their lawsuit is all about the use of this, but that's what it's about. It's about essentially
they can do that now today.
Model.
Guys, they can do that now today just by reading the newspaper. People can, this is what people do in school. They research. They look at a newspaper, they research the article, or they cite and as long as they cite the source, they're okay. They use that for educational purposes. I think
that's the problem, though. They don't cite the sources. That's the problem, right? So they're presenting something that is essentially an opinion. Like if you asked a student today, to go off and come up with a study on something, they might come back with it and say, okay, here's my findings on this. But what they're presenting is their findings. It's not their findings, it's someone else's findings.
Well, what the conversation you're having is what makes this such a great topic. I mean, if I was doing a law school seminar and asking students to debate, like, what should be the legal principle, what kind of how would we apply copyright principles that exist, or how should we draft new legislation? The debate you're having, that we're all having, is the starting point of the conversation we need to have. That's, when we came along to advocate for accessibility legislation, we started out with the fact that there was no common law right to equality at all. The most that we could do is turn to new legislative requirements that any number of us fought for 40 years ago: equality in our human rights, anti-discrimination laws, equality in our constitutional charter of rights. But we didn't have any common law principles to start from at all that guaranteed us a right to accessibility. We had to start building on legislation and then saying, maybe we need new legislation to make it happen. It's the same kind of thing. And that's just one, the copyright thing is just one legal thing. Let me give you a wonderful science fiction fun example. For those who've watched the movie 2001, spoiler alert, I'm going to give something away, but HAL, the computer on the spaceship, which is a form of AI, kills deliberately one of the astronauts because he's afraid that he's Frank Poole, because he's afraid he's going to unplug him. And so you can't prosecute HAL for murder, but it's a murder. Can you prosecute the manufacturers of the AI for murder, or maybe criminal negligence causing death for designing software that could kill someone without the proper safeguards? Like, how do you apply legal principles of criminal law to conduct caused by AI? Just one other.
Well, I was going to say, David, that's one other thing, of course, with driverless cars is the same argument, right? There's that ethical side of this. How do you, who do you complain to if the driverless car hits someone on the road? Because you've got a situation where the car is doing something as pre-programmed. So can you blame the car? Do you blame the company? Do you blame the person for getting in the way of it? What do you do here, right? So this kind of leads into that ethical side of the debate as well, which is very interesting.
See, that's not just an ethical one. It's a legal one. It's a tort civil law one. Who can you sue, and what can you sue them for? It could be a contractual one. If it's the driver whose car goes out of control and they get injured and they want to go after the Tesla or whoever, and it's a potential criminal one. So criminal liability for the company that put the product on the market. And so there is a long list, of which the New York Times copyright lawsuit is just one. How about defamation? What happens if some AI produces something about you or your program that's defamatory? Who do you sue for libel?
Well, that came up.
You can't do that.
That came up in recent elections, and going into election, for example, in the U.S., what's stopping someone from deep faking our voices and the day before an election saying something atrocious about one of the candidates that actually affects the election? Those are things that we have to consider. Well,
Yeah, no,
well,
no,
these are ideas that
absolutely.
are already out there. I promise you, this has been going on for quite some time. It's interesting that all this stuff is happening. It's like chicken before the egg. So AI come here, everybody sees how great it is, and now the governments are trying to figure out, how do we regulate this? How do we control this? How do we protect people? How do they cite the sources? I don't think there's a definitive answer for this. I don't think anybody has the answer. I honestly don't, I'm not even sure if our government and lawmakers are even have enough information to make any kind of definitive answer here. David, what do you think?
Well, there isn't an answer. There's going to have to be a multi-pronged answer, and it'll probably be some common law of using, or some complex mixture of new legislation and trying to apply old common law principles or apply existing laws like copyright. But let me give you one where this converges with accessibility. We know that AI can be a source for accessibility, like Seeing AI and those other apps that we love. But how about those AI-driven products that some employers use to screen resumes to decide who to interview for a job?
Mm.
Well, this is where you could automate. There's a book called Automating Inequality, and this could be a place where we automate inequality, because the criteria they may use for how to screen resumes may not involve the kind of flexibility that will take into account the fact that some people with disabilities may have weaker resumes because they face so many barriers getting jobs. And therefore they will perpetuate discriminatory employment practices. And you'll never get an interview so that you can prove, strut your stuff and prove that you're worth being hired, because the AI screened you out using those. So there's a potential for AI deployed in that job resume vetting technology for actually being a source of systemic discrimination against people with disabilities.
Yeah, that's super. That's an interesting take. We've got a really cool story coming up after a quick break here, David, where a student has actually turned to AI to help him, and there's, it was a situation where he could have said, "Okay, I'm done. I'm going to quit," or I might find a solution. So we're going to take a quick break. Stick around. When we come back, we're going to hear that story from the student himself, Aaron Ramirez, and David, you're going to be joining us again, so we can pick that apart. It is Access Tech Live. We'll be right back.
There's more Access Tech Live to come. Get involved and have your say at Access Tech Live on social media. We'll be right back.